You ready? We'll call us to order. First order of business, those who are able, would you join me in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And those who are going to testify, if you'll stay standing, I'll swear everybody in who's going to testify today. Do you all swear from the testimony you give us the truth, the whole truth, and nothing but the truth? Thank you. For the respondents here today, my name is Drew Smith. I am the Code Enforcement Special Magistrate for the City of St. Cloud. I am not an employee of the city. I am retained for the sole purpose of being an independent trier of fact in these hearings. I'm a private practice attorney. Been practicing local government law for 22 years. And the order of business on each case, the code enforcement officer will present. When they're done with their presentation, you will have an opportunity both to ask questions of the code enforcement officer related to the evidence they have presented. If you have no questions for the code enforcement officer, we can go right into your testimony that you'd like me to hear today. If you have any documentary evidence, you can present that, but just understand that anything you give me, I have to keep as a public record. So if you're giving me something, make sure it's a copy. And with that, clerk, you may call our first case.
Case number 2024-917, Ana Maria Frias Segovia, Daniel Nam Rojas, Gretchen Denise Rojas, owners, location of violation, 1603 Eastern Avenue, St. Cloud, Florida.
Good afternoon, Melissa Howes, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: a copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail, a copy of the notice of violation sent by regular mail posted on the property and City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $270.96. The respondent is here and has been provided copies.
You can stay seated, and when they're done, I'll call you up.
On June 4th, while investigating another violation on the same street, I noticed that there were two mobile units / recreational vehicles still on wheels parked in the driveway of this property. The larger unit appeared to be over the required length permitted by code and was hooked up to electric. There were no permits on file for the unit, and it appeared that someone was living inside the unit. The smaller unit was still on wheels and appeared to meet the length requirements. However, it was hooked up to utilities with no permits on file and may not meet the proper setbacks required by code. I took 3 photographs. So the larger unit is the one on the one on the left of the screen closest to the dwelling, and then the smaller unit is towards the back there with a little bit of orange on it. It's a close-up of the smaller unit, and that was just a photograph of the house numbers. On June 5th, I created a notice of violation and sent it out by regular mail, giving the owners 10 working days to obtain all the proper permits needed to correct all the violations. On June 21st, a reinspection was performed and none of the violations had been corrected and nothing had been submitted to the building department. 4 photographs were taken. That's the electric hooked up to the big unit. That's the electric to the smaller. And that's both of them. On June 24th, I created another notice of violation and sent it out by certified mail. While checking another violation on the street, I stopped and took 2 photos showing that the sewer line was hooked up to the unit. Oops, I must have went too far. On July 10th, I had not received the certified mailing card back signed, and no permits were on file. The owner had not reached out, so I sent out a new notice of violation by regular mail, posted the property and City Hall, did an affidavit of posting, and took 3 photos. On July 11th, I did receive a phone call from one of the owners, Daniel Rojas. who stated that he had received my notice. He stated he reached out to an electrician to pull a permit for the electrical work performed, and the sewer lines from the units are tied into a septic tank, and wanted to know what kind of permits did he need for that. I advised him that new septic tank unit permits are regulated through the county health department. However, the piping he did after his certificate of occupancy would require a plumbing permit to ensure the size and materials are within code. He also stated that his cousin was residing in the larger unit until the end of the month, and when family members visit, they use the unit to stay in. As for the smaller unit, he said that was for his own personal use. I explained to him that if the units are hooked up to electricity, water, and sewer, a permit is required for the hookups, and there are codes that must be followed on the size, setbacks, and permits depending on their uses. He asked that I give him some time to work on getting the permits. On August 20th, over a month later, I checked and nothing had been submitted and no phone calls received. I went by and performed a re-inspection, and the units were still located in the same spots, hooked up to utilities. 3 photographs were taken. On August 21st, I sent out a statement of violation and notice of hearing by certified mail, posted the property and City Hall, did an affidavit of posting, and took 1 photo of the posting. I think I stuck that in there from the property appraisers, showing you the dwelling from up high. I must not have stuck my posting in there. He did sign for the certified anyway, by the way. So on September 17th, and again today, I checked the permit records and nothing had been submitted, and none of the owners have reached back out to me. It is the city's recommendation that the respondent be found in violation of allowing electrical, plumbing, and the placement of mobile units/recreational vehicles prior to obtaining the required permits by the time specified. The city would like to give the respondent until October 18th, 2024 to correct all the violations or pay a fine in the amount of $250 a day until compliance is met. The city would also request that the cost incurred in bringing this case before the magistrate in the amount of $270.96 to be paid within 7 days of the written order by the special magistrate. And that concludes my presentation.
Thank you.
Mm-hmm.
I don't think you were sworn in when I swore everybody in, were you? Do you swear from the testimony you give us the truth, the whole truth, and nothing but the truth? And if you'd start by stating your name for me.
Daniel Rojas.
Okay. Did you have any questions for the code enforcement officer before I started on your testimony?
No question.
Okay, let me to hear.
The only thing, I already sold the property. I just wanted, you give me already to the October 18th, so hopefully the new owner will remove, what we're talking about. And I
You
will
say you
bring
sold the property, or you're selling the property?
No, I already sold the actual large mobile home.
Oh, the mobile home, you
RV.
sold, not the property, but
Not
the
the
mobile
property.
home. is
Yeah,
you
yeah,
sold
the-
them. Okay,
the,
gotcha.
The recreational vehicle has been sold already, but the new owner hasn't picked it up. That's one of the reasons why I haven't, cleared out the violation. But hopefully,
Do you foresee any issues with that being picked up by October 18th?
no, definitely not. I already told him, listen, I got a court date today. She's aware of I'm here today, hoping that you already give me some time, which you already did, which is I'm really thankful for. So I'm kind of pushing her to get everything removed so I can get, all the electrical improvement, plumbing removed, and put the permit of the electrical one, because we're going to keep the smaller one. The smaller one is not an issue, and it has a license plate. But I want to keep the AC just in case of the mall and whatnot. The sewage doesn't have to be plugged in. The sewage, it just is connected to the septic tank of the house. But I really like to keep the electrical just in case because of the AC. I don't want no more to be growing in the unit because I really use it, sometimes.
So you're going to get that electrical permit?
Yes, I already talked to the electrician. He told me just to remove the bigger unit. Once we remove the bigger unit, because the other one obviously not complying, and then he's going to go ahead and put the permit for the one that is already.
And again, no, you don't foresee any issues with that getting done by October 18th?
I don't think so. I'm going to do everything that's in my power to move it because I really don't want to be in this
If you do run
fight.
into roadblocks, reach out to code enforcement and
Okay.
let them know, give them a time. If you're going to be a day or two late, let them know so
Okay.
that they're aware.
Absolutely.
They will,
I really appreciate it. Like I say, I do everything in my power. I don't want to be sitting in this situation again. I mean, I talked to her and asked for some time, and I will make sure that I make it happen.
okay. Anything else you'd like me to hear?
No, sir, thank you. Appreciate it.
So the code enforcement has asked me to impose the cost of the prosecution, which by statute, there's no reason why I should not, but they've asked for it to be paid in 7 days. I typically, when somebody has taken the time out of their day to come here and shown the respect you have, I will ask, do you need more time than 7 days to pay the $270?
I can pay it right now. If I just tell me where I need to go, and I'll go ahead and pay it now.
Then that's easy too. Then based on the evidence testimony that I've received, I find in favor of the city, find that the respondent is in violation. Order the respondent to cure the violations by October 18th, 2024. If not cured by that date, a fine in the amount of $250 a day will run until compliance is met. As you've said, you're confident you can get it met by October 18th, but again, if you have any trouble, let code enforcement know as soon as you know there's going to be a delay.
Okay.
And I also order the respondent to pay the administrative costs incurred by the city in the amount of $270.96. That amount will be due within 7 days of the date of my written order, which you'll receive in the mail. So everything that I've just ordered, that I've just ruled, I'll put that into a written order. That will get mailed to you by certified mail, so you'll receive that. And that's actually the trigger point for when that clock for payment of the cost starts to run.
All right. So I just mail a check.
Yes, sir.
Okay.
It'll have instructions in the order.
Perfect. Thank you.
Yes,
Appreciate
sir.
it. Absolutely. Thank you. Thank you.
Case number 2024-1018, Cindy M. Jimenez, owner, Julian Eduardo Ramirez, owner, location of violation 3061 Dreama Drive, St. Cloud, Florida.
Good afternoon, Pam Neal, City of St. Cloud Code Enforcement Officer. I am presenting this case for the property located at 3061 Dreama Drive. At this time, I would like to enter into evidence the following items: copy of the notice violation sent to the owner, copy of the notice violation sent by certified mail to the owner and posted on the property and City Hall, copy of the statement of violation notice of hearing sent by certified mail to the owner and posted on the property and City Hall, copy of the affidavits of postings, copy of the PowerPoint presentation, evidence of mailings, copy of the deed to the property, copy of the code section in violation, copy of the costs incurred if the special magistrate finds the respondent in violation in the amount of $241.96, and the respondent is not here. On June 28th, 2024, I received a complaint about the grass and weeds dislocation. On July 1st, I went to the location, and the grass and weeds were pretty high. On July 2nd, a notice of violation was sent to the owner. On July 10th and 15th, re-inspections were performed, and the grass and weeds were not mowed, and I took 3 photos. Well, 6 photos total, but 3 on each day. On July 16th, a notice of violation was sent by certified mail to the owner and posted on the property in City Hall. An affidavit of posting was completed, and I took 1 photo. On August 6th, the re-inspection was performed, and the grass and weeds were still not mowed. On August 7th, a statement of violation notice of hearing was sent by certified mail to the owner and posted on the property and City Hall. Affidavit of posting was completed, and I took 5 photos. On August 20th, a re-inspection was performed, and the grass and weeds were not mowed, and I took 3 photos. On August 30th, a re-inspection was performed, and the grass and weeds were mowed, and the property was now in compliance. It is the city's recommendation that the respondent be found in violation of allowing the grass and weeds to be above the height of 8 inches at this location. The city would like to also recover the costs incurred in bringing the case before the special magistrate in the amount of $241.96 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
Is the residence occupied?
Yes,
Owner occupied, or is that a tenant there?
it's an owner.
Is there a health issue or anything? Are you aware of anything?
I knocked on the door a few times, nobody come.
A long time without getting cut.
It was really high.
Yeah, the only reason why, obviously, you presented the confidential evidence in favor of the violation. I'm just curious, hoping you don't have to deal with it again.
Let's hope not.
So I will enter that order. finding that they were in violation, failed to cure it within the time set in your notice of violation, future violations will be treated, may be prosecuted as a repeat violation. We'll also order the respondent to pay the administrative costs incurred by the city in the amount of $241.96. That amount will be due within 7 days of the date of my written order.
Thank you.
Thank you.
Unfinished business, notice of hearing and motion for authorization to foreclose on code enforcement lien, case number 2023-1564, Bertha M. Steele Estates, owner, repeat violation, location of violation, 1810 Kentucky Avenue, St. Cloud, Florida.
Good afternoon, Jack Morrison for the city. Mr. Magistrate, Mr. Tim Steele is here on behalf of the respondent, just behind me here, and I have briefly discussed with him the motion that you have in your packet. He has a copy as well. As you see, this was a case that was heard by you back in February of this year, and then an amended order was issued with regarding the imposition of a fine regarding a repeat violation for abandoned vehicle, exterior property in an unsanitary condition, high grass, weeds, etc. And the fine was imposed going back to August of last year, and a substantial fine of over $180,000 has been incurred. As my understanding, as of today, the property has made some improvement. Officer Bennett is here to substantiate that fact if necessary, but the property remains in noncompliance. As I explained to Mr. Steele, this is sort of the last procedural aspect of the code enforcement, simply seeking the authorization from the magistrate for the authorization for foreclosure, should the city at some point wish to consider that. There's no suggestion that they will, but that it's just that we have procedurally met the requirements. The order was recorded in May, and my motion was filed in mid-August. That's where we are.
Okay.
Thank you, sir.
And Mr. Steele? And just for the record, I know I've heard it, but if you would state your name for the record. please.
Tim Steele.
Thank you.
Really, all I can do is apologize. Me and my wife moved down here to take care of my dad late last year. He passed away. We didn't know he'd had a stroke, and he had just let the place get into really disrepair, inside and out. Me and my wife both have health issues that came into play during all this time too. But we've tried. We've hired people to come in. They've taken advantage. We gave trailers to people to come in and haul stuff to the dump. They would come in, basically threw the stuff off the trailer into the yard, took the trailer. We never seen them again. That happened 2 times to us. We have this past about week and a half, 2 weeks, our son's moved in with us, and he's helping us now. So that will help overcome our health issues that we have. Because I have a bad shoulder and bad knee, and my wife has serious issues too that keeps us from doing some of the heavy lifting. But that's essentially what's happened. All I can do is apologize. We've definitely not done what we should have done.
And lots of I will say this. I appreciate the demeanor. I tell you, my sympathies are with you, and you do. I appreciate the apology, but don't feel like you owe these. This is life, and it happens, and I think everybody here understands that. As you've heard from the city attorney, though, this is a procedure this is a procedural motion, and really, have they recorded a lien? Has it been recorded for 90 days? If so, I check the box,
Yes.
and I give permission. I am encouraged to hear that often when I'm in the city attorney's role in other cities, we're coming and asking for this permission. Our next step is city council to ask for permission for the money to file the lawsuit. So it sounds like you're not there. That's encouraging based on what you're telling me, because it sounds like there is still room to work with the city. And the first step in that, as promptly as you can, keep making constant progress, certainly, because the more good faith you show, the better that conversation is going to go. But until you have it in compliance, the city's really stuck. The city can't negotiate a reduction of fines until the property is in compliance. So keep working steadily and as promptly as you're able to get those violations cured. And when you do that, then come to the city and say, we'd like to request a reduction of fines. St. Cloud is a little bit different than other cities because they've incorporated into their code. They've given me permission to reduce fines under $50,000. This obviously would not be one of those. But I hear all of them. I make a recommendation to the city commission for those that are over $50,000. So you would see me again if we get there. And the city has been very reasonable. The city manager has been very reasonable in how they will work with people on cases. I would like to think I'm very reasonable in those that I've approved, and the same for the city commission. So I think if you can just keep showing that good faith like you're showing today, I think you can get through this. Okay?
Thank you.
Is there anything else that you would like to say, or that I can say to maybe help encourage you forward?
No, I think the encouragement's there at this point. So that $180,000 kind of hit me like a brick in the face when I seen that. It's hard to believe it doesn't seem like it's been this long. I swear to God, it just really doesn't. We've been trying
We've
to
been
do
going through a
things.
lot too, though, and time
We
goes fast.
are.
when you're going through a lot.
And it got away from us. But we're on top of it. It's our number one priority at this point to get this taken care of. We're kind of in some financial distress, so we have that to overcome as well. But we're going to keep making progress at this one way or the other.
Okay. Well, that's good to hear, and steady progress. You know, how do you eat an elephant? One bite at a time. Right. So I am going to enter that order authorizing the foreclosure, but keep moving forward. And keep in touch with the city. Let them know your progress. Let them know that you're working on it.
I will do that.
Okay.
Thank you.
Reduction of liens under 50,000, case number 2011-1907, Alan J. Fink, owner, location of violation, 20 Massachusetts Avenue.
Jack Morrison for the city. This is one of those cases, as you just referenced, which is a lien that had reached the amount of $14,500 dating back to a violation which was heard by you some time ago. But the respondent proposed a resolution of $1,466.61, which was countered by the city manager at $1,632.69, which we understand was accepted by the respondent. And so we're asking that you would approve the reduction to $1,632.69 to resolve this matter in its entirety for Mr. Fink.
I will enter that order approving the reduction to $1,632.69. That's all inclusive?
It is.
Okay. And I will enter that. And if not paid within 30 days, it reverts back to the original amounts.
Sir, thank you.
New business none. Next scheduled meeting, October 16, 2024.
Can you email me a copy of that, please? Anything else from code enforcement? Anything else from clerk? No. Then we are adjourned.